Witnesses are one of the most common ways that attorneys introduce information to a court of law. In a case as a witness, you may either be the plaintiff, the defendant, an eyewitness, character witness, or an expert witness. As the plaintiff, you are the party who is driving the case forwards. As the defendant, you are opposing the plaintiff. An eyewitness is most commonly used in a criminal trial as they report information. A character witness speaks about a certain party as they would be a close friend, relative, or co-worker. Finally, an expert witness is a specialist or a professional in a particular field which is related to the trial. For example, an expert witness may be a graphologist who is brought in to analyze handwriting. Witnesses will be heavily involved in both the trial and pretrial motions via depositions. If you are subpoenaed to testify at a deposition, understand that everything you say is viable in a court of law. You will be sworn in by the notary, and the deposition will be recorded for later use. Attorneys may later use statements you make during a deposition in court. In a deposition, you will first be examined by the party who subpoenaed you, and then you may also be examined by the opposing counsel. Generally, in mock trial cases, as a witness, it will be clear where you stand in regards to the counsels. For example, in a criminal trial, an expert forensic scientist may speak for the prosecution. Alternatively, as a relative of the defendant, you may be a character witness for the defense counsel. Whenever you testify, be it at trial or in a deposition, you may ask for questions to be repeated, clarified, or rephrased. You may also exercise your Fifth Amendment rights if the case is being held in a court in America. This is also known as the Miranda warning or the right to silence in other countries. In trial, prior to a witness taking the stand, there are opening statements which inform everyone in the room what the case is about, who is involved, and what the charges are. As a witness in a mock trial, you will be subpoenaed to testify in trial by a counsel. The attorney who subpoenaed you will ask you a round of simple structured questions in an effort to bring out evidence to support his or her case. This is called the direct examination, after which opposing counsel will ask you a round of questions of their own. Opposing counsel may only ask you questions relevant to the questions asked in the direct examination. Theoretically, after this, the judge may allot extra time to a redirect, where again you will be asked a round of questions relevant to the previous two. In both a deposition and in trial, your attorneys or the attorneys who are not asking you questions will protect you and the information you own through objections. Familiarize yourself with what you should say and what you shouldn't based on the case materials and the advice of your attorneys. Attorneys may argue that the questions you were asked were ill-structured, irrelevant, or simply illegal. If a judge sustains the objection, it means that the judge agrees with the objection and disallows the question, testimony, or evidence. If the judge overrules the objection, it means that the judge disagrees with the objection and allows the question, testimony, or evidence to be submitted under oath in court. You may discuss tactics and strategy with your attorney. However, they cannot ask you to lie under oath, for this is known as perjury. It is important that before a deposition and before trial, your attorney briefs you on the type of questions you will be asked and to what end. They may even prepare example questions for you to practice with in order for you to develop your story in your head. If, as a witness, you ever have a question about your character, you must speak with your case manager. In most situations, you should form details and facts about yourself around the information you are presented with. You need to improvise a personality based on the information in course reports. Finally, whenever you speak, ensure you stay in character, memorize any important facts you may be asked, and ensure that there are never any discrepancies between any two testimonies or information provided in the reports.